Welcome, everyone. We are so excited to have you here for our program today. My name is Kerry Sautner. I'm the president and CEO of Eastern State Penitentiary Historic Site, and it is wonderful to have you all here today. Today, we're going to dive deep into the Eighth Amendment. It is Constitution Day for those of you that are not sure about what that holiday is. This is the day we formally observe to celebrate and talk about the United States Constitution. So Eastern State Penitentiary's mission and vision is to talk all about the criminal justice system and criminal justice reform. So our focus is to increase awareness, education, and understanding of the criminal justice reform movement and its impact on people today. This work will help all of us build a stronger community of understanding, a respect for basic human dignity, and an understand the effect of positive change can have on our judicial system. So what a better day to celebrate and to dive in and to understand further the Constitution with a focus on the Eighth Amendment. So I'm coming to you live from Eastern State Penitentiary Historic Site. This is an amazing site in Philadelphia where we do this amazing work, but we're also reaching people across the country. Today, we're going to learn about our past, we're going to understand our foundation, and we're going to talk about some of the current issues. And we do these programs, and this is one of our first of our online programs for the year that we're kicking off, but we also bring in great scholars and teachers from around the country. Today, we are so lucky to have two amazing teachers with us, Amy Fettig and Kermit Roosevelt. First, I want to welcome you both to our first kickoff of the season program.
Thanks so much for having us. Really happy to be here.
Good to be here. It is great to have you both here. I'm going to walk through some information about our two scholars, but I have to just share with everybody. This program is a fantastic one to dive into, but I get to meet somebody new. I have never worked with Amy before, so it's so great to dive into the current issues with you, Amy, but also feel like I'm at home because I've worked with Kermit for years, Kermit Roosevelt, who's at Penn, not too far from Eastern State Penitentiary. So this is a wonderful balance of having scholars that I've worked with in the past and new scholars. So thank you again for being here. And let me tell you all a little bit about our two scholars today. So Amy Fettig is a national expert on criminal justice reform with over 2 decades of experience as a civil rights litigator, a campaign director, and movement leader. Amy previously has served as the executive director of the Sentencing Project. It's a research and advocacy organization based in DC. This is where she oversaw a groundbreaking research on sentencing reform, jumpstarting a national campaign to roll back extreme sentencing, expand voting rights, and promote youth justice. Amy also served as the deputy director for ACLU's National Prison Project, where she garnered national recognition for her work challenging unconstitutional prison conditions. Amy, you have done so much work on this, and we're so glad to have your voice in this conversation today. And just one thing I wanted to note about so much of your work, but also what today is on top of Constitution Day, it's also National Voter Registration Day. So I just wanted to take a beat and take a moment and share that with everybody online who's joining us today. Voting is an important thing that we can do as citizens. We can talk a little bit about it today and the right to vote for formerly incarcerated people, but it's also something that is a civic holiday, and it's civic engagement. So remember, if you go to vote, bring a friend, bring somebody who hasn't voted before, go together. It is a great thing to do together, and it helps make people believe that this is something that they all can do and feel comfortable with. We're also joined by Kermit Roosevelt. Kermit is the David Berger Professor of Administration and Justice at the University of Pennsylvania Carey Law School. He's the author of numerous law review articles and several books, most recently, The Nation That Never Was, Reconstructing, America's Story. Before joining the Penn faculty, he clerked for the United States Court Justice David Souter, and in 2021, he was selected by President Biden to serve on the Presidential Commission on the Supreme Court Reform. He is also the author of 2 novels, Allegiance and In the Shadow of Law. Thank you both for being here with us today, and I cannot wait to dive into this conversation. Anything you'd like to kind of set our participants and their people joining us today around the country, something that you want to hold on to throughout this program that we'll circle back with in the end? So big idea
well, for
around
me,
the eighth. Yeah,
big
sorry,
idea,
go ahead.
big idea. I would just say, America, the Constitution, all of this, we should think of our nation and our Constitution as a work in progress. So, we have it now. It's not necessarily the best it could be. There's the amendment process explicitly set out in Article 5. So we should always try to be getting better. That's my big takeaway.
Love it.
Absolutely. And I'll just add that that is really built into the idea of the Eighth Amendment prohibition against cruel and unusual punishment, that what constitutes a violation of Eighth Amendment is not trapped in amber. It's not about what happened in the 18th century. It's about what we value today. And unfortunately, many of our laws and practices still don't reflect those values. And we'll talk about that more.
That's a perfect prelude and kind of almost an understanding of what we can carry outside of this classroom and this program as well. So let's dive into what did they write in the 1800s and where the 18th century and where did that come from? So Kermit, I want to kind of kick it over to you. I always like to start with the words of the Constitution, the words of the document, or the words of the people. So when we think about the Eighth Amendment, feel free if you want to read it out loud, or I can read it out loud, but I'd love you to help us to understand when crafting the Eighth Amendment and adding it into our Constitution, where did these ideas come from and what was the reasoning behind them?
Sure. So the Eighth Amendment says excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishment inflicted. And what that's about basically is protecting people who are caught up in the criminal justice system. Because we understand the state, when it's making criminal laws, when it's punishing people, it has a lot of power. And one, we're concerned that that power might be abused, that people might try to punish their political opponents or something like that. And we've got other constitutional provisions that are designed to reduce that harm. But we're also concerned just the state is very powerful. It can inflict great harm on people. And people who are being convicted of crimes or charged with crimes, some of this is pre-conviction, some of it is post-conviction, those often are people who don't have a lot of political power. And the system isn't necessarily going to be very responsive to their interests or their voices. So those are the groups that need constitutional protections that can't be set aside just because a majority wants it, just because lawmakers might think it's a good idea or it'll make them popular with their constituents, right? Inflicting harm on vulnerable people is often a good political strategy. So we try to set out some rules that guide us and can't be transcended.
Now, thank you for that. And I think you bring up a really important point that we're going to unpack today. And Amy, I think your voice is really going to be helpful in understanding this. So often people tend to look at the Eighth Amendment and think about if you're accused of a crime. But how does the Eighth Amendment really balance between that pre and post, what Kermit just kind of spelled out? How does the Eighth Amendment apply before you're convicted of a crime and maybe after you're convicted of a crime? Do you want to kind of unpack that a little bit? And then Kermit, I want to go back to you about the influence on the founders for the.
Yeah, well, I do think it's a lot of people get this issue confused, and it actually is important. The difference between being pre-trial and being accused of a crime and being convicted of a crime. So people are held in jail generally pre-trial, although sometimes if they have a short sentence or if they have violated conditions of probation or parole, they might be held in a jail. But once you're convicted, you're held in a prison. This is kind of technical, but it is important to remember. The Eighth Amendment, prohibition against cruel and unusual punishment, fancy 18th century term for torture in many ways, that actually applies just to prisoners. But that doesn't mean that people who are held pre-trial are unprotected. In fact, under our laws, they should have more protections because they can't be punished. So they're protected by our 14th Amendment due process guarantees. Unfortunately, in practice, most courts have treated prisoners who are convicted of a crime and people who are accused of a crime for legal reasons exactly the same. There are a few exceptions for that where the law is evolving, but it is still fairly universally not in practice giving people more protections. And that means a lot, because on any given day, hundreds and hundreds of thousands of people are held in jail because they're accused of a crime. They haven't been convicted of anything. And generally they're held there because they are too poor to pay bail. Not because they're actually considered a danger to the public, because they are too poor. And so we have to start asking ourselves, does this mean that in the United States, we have debtors' prisons?
This is a really interesting topic. And, I've been here at Eastern State for 2 months now. And one of the things that we have been talking about is really examining the criminal justice system and, the question of, are we a fair and just society? So not just looking at the Eighth Amendment, but going back to the preamble and looking at we the people in order to establish, have we established a fair and just system? And it is the question around, before, pre-incarceration, during incarceration, and after. And it really, those layers interact with each other, but we have to look at these in different perspectives and understand how the law affects people and where are people's rights being considered, suppressed or enforced, and really understanding those pieces. Now, Kermit, before we kind of dive into how it has moved along since Reconstruction and since the early 1900s, I'd like to get a little framing from you about why did the framers put it in the Constitution in the first place? What was their considerations? What was their worries? We think about that Constitution of 1787 as a document that is to restrain the government, like you said, but where are the stories? Who are the people that we should pay attention to when we look at the Eighth Amendment?
Yeah, so a lot of the constitutional provisions in the 1787 Constitution and in the Bill of Rights are responses to particular bad things that happened. Some people say rights come from wrongs. So one interesting exercise, if you'd like to try this at home, is you can read through the Declaration of Independence, you'll see various complaints against King George, then you can read the Constitution and see if they've been responded to. Do we try to fix the bad things that King George has done? Now, the Eighth Amendment isn't actually an example of that because the English had it already. So the language of the Eighth Amendment comes pretty much directly from the English Bill of Rights of 1689. And that is a reaction to bad things that happened in the past. The history is a little bit murky exactly what it's a response to. Some people think that it was designed to prevent a repeat of what was called the bloody assizes, where judges were inflicting wantonly cruel punishments. In terms of particular people, there was a man named Titus Oates, and he's the one who's most commonly mentioned as one of the inspirations for this. He perjured himself, he lied under oath, and his false testimony led other people to be executed. And so they imprisoned him for life because of this. But then also they were going to take him out once a year and parade him through the streets of London, whipping him all day for the rest of his life. And so you have a bunch of punishments that were commonly inflicted, imprisonment and public flogging and so on, but they combined a lot of them in this novel and pretty horrifying way. So basically the general story is, if you look back, people did things like this in England, and the English reacted against it. At the time the Constitution was being drafted, other countries had punishments that we thought were barbaric. So if you look at the deliberations of the Constitutional Convention, one of the things that people say about the Eighth Amendment is, we don't want to be like Germany or France or Spain, where they do these terrible things. And then there's an interesting way that plays out as time goes on, and people start arguing that maybe European practices should inform our understanding of the Eighth Amendment, but we'll probably get to that later.
Thank you, Kim. That was fantastically helpful to kind of understand that framing. I was reading a book by Jen Mannion in the last couple of days and diving deep into Liberty's prisons, and looking at, some of the things that you raise, Amy, around, are you in jail because you can't pay a fine? And looking at the 16 and 1700s, you have these stories. You have the beginning of a reform movement in England. You have the beginning of the reform movement looking at these prisons and saying how horrible the conditions are, but also saying, well, if somebody's poor and they're in there, they can't get out because they can't pay the fine. So I'd love for you, Amy, kind of dive into this, and Kermit, maybe give us a little bit of foundation of what came before Eastern State. If Eastern State is open in 1829, what's happening in the colonies and in America before that? So Amy, why don't you take a beat on, are we keeping people, with excessive bail when that number is just unfathomable for them to reach?
Well, absolutely. I mean, those prisons were actually pretty common in the UK, and that really is, it's a tax on the poor. It is criminalizing you because you are poor. And many people argue that's still happening in the United States today. I think it really is important to remember that we are still the country that incarcerates far, far more people than anybody else. This is the 50th anniversary of mass incarceration in this country. And the vast majority of people who are in prison in the United States today, poor. They're poor people of color, they are marginalized individuals. And that historically has been true. You also have to remember that prisons in the 18th century were actually a progressive idea, because previously corporal punishment, execution, all kinds of torture was very, very common. So people thought prisons, and in particular Eastern State, ironically, with its capacity to hold people in long-term solitary confinement, that was seen as a humane effort. Unfortunately, as we'll discuss later, it was soon disproved in its ability to be humane, and the modern incarceration that we have now with massive solitary confinement across the board is something I think even the Quakers could not have imagined. And it's ripe for Eighth Amendment analysis.
Kermit, did you want to kind of pull in a little of the story around like Walnut Street Prison in Philadelphia, right behind Independence Hall, and the connections between that moment of liberty in America in 1776, 1787, and the juxtaposition physically of a building of liberty and a building of a loss of liberty?
Well, I'm not actually really an expert on the history of the Walnut Street Prison or prisons in America, but I do think that it's interesting that, at the same time you've got people talking about the inalienable right to liberty, you've got people who lose their right to liberty in a prison. You've got people who lose their right to liberty because they're enslaved, obviously, sort of another example. But maybe a way to think about the progress and the history of prisons in the United States is to think about the way that we think of imprisonment and the way we think of our response to crime. So as Amy was saying, the early criminal system is much more focused on punishment. So someone breaks the law and you punish them, and that's what you're trying to do. And prisons are supposed to do other things. So people understand being locked up is unpleasant and being taken away from your family and your loved ones. So it does serve as punishment, but it's also supposed to incapacitate people so that they just can't commit crimes anymore. You take them out of society and they're not going to pose a threat. And also it's supposed to rehabilitate. So this is sort of the big innovation that the prison system is doing. No one thinks that being flogged is going to make you a better person. It might deter you because you're afraid of it happening again. But the idea behind the prison really was that these are people who've sort of lost their way and we can try to make them better.
So this idea of evolving and reforming is been almost innately since the colonial period on in America's conversation and the world's conversation. I think that leads us perfectly to some of the court cases around these questions. Have we found a balance? Are we striking a balance? And where do we move forward? And where is it not meeting? Because when we look at the words of the Eighth Amendment, excessive bail, cruel and unusual, they're very, very open to interpretation. And Amy, you brought this up earlier, the question of how do we interpret these? Do we look at the original intent? Do we look at a modern interpretation and dive into it? I'm going to read a quote from Brian Stevenson, who we know is a part of the Equal Justice Initiative. Here's a quote from him about the interpretation of it. As our notions of fairness, equality, and justice have evolved, so too must our interpretation of the Constitution. No provision of the Constitution enshrines this principle more clearly than the Eighth Amendment. Now, Amy, I'd like you to kind of help for us to understand the evolving nature of the Eighth Amendment around standards of decency. What does that mean? And a few of the court cases that our students may want to explore when trying to understand how has our country grappled with this over time.
Absolutely. And you know, the Supreme Court has very specifically held that the Eighth Amendment has to be informed by evolving standards of decency as our society matures. And so when we bring cases before the court, we emphasize what we think the community feels about an issue, or what legislatures say about an issue, about associations. So all the evidence of how does the community really observe these particular practices? Are they a moral affront to what we think of as our American values, for example? And so we've seen the court grapple with this as society has grappled with its own evolving morality, and also, frankly, things like evolving science. So this is very evident in some of the cases around the death penalty, for example, or the incarceration of people who are children when they commit their crimes. In both those circumstances, we now have case law that says, hey, you can't execute a child, somebody who committed a crime as a child. And also, if you're considering sentencing a child to life imprisonment, and there has to be extra protections. And the reason that evolved is because now neuroscience tells us, hey, human brains don't evolve, frankly, until the age of 25, roughly, around the frontal lobe, and that controls people's impulse control. It controls their future thinking. It controls their maturity. So we have an understanding of children and young people that we never had before. And that has informed court decisions about what constitutes cruel and unusual punishment. So those are two very clear examples. And we want to continue to evolve around those issues as science tells us things, as frankly, some of our common sense. Because, you know, if you've ever had children or been a child, you know that they are different than adults. But now science actually confirms that to the courts. Hey, we have to evolve our laws in order to protect people in a way that in the 20th century and in the 21st century, we think is appropriate.
Thank you. That understanding kind of the influence of the science, influence of the settings, really, it will bring me back to the reason for reform in this institution, and understanding that even though a great idea starts, it could be absolutely, with scientific research, known to be the worst idea. So looking at conditions of confinement. So Eastern State was established under the idea that if you were brought into isolation, brought into time that you could repent, have time alone, have time reading Holy Scripture, time to think about what you did, that would be the reform. That would be your way to pay penance and move and change from that life. So thinking about that, area of confinement, we know today that solitary confinement is unbelievably, in long term, unbelievably dangerous for people. So I'd like to understand, from Amy, from your perspective, some of those modern cases and how they affect people directly. And any people you could name specific in these cases would be wonderful for our students to understand, is we like to make sure we're talking about the people here at Eastern State. And Kermit, for you, help the students understand that it's not just the Eighth Amendment. What other parts of the Constitution are being deployed when we're looking at, the rights of the accused, the right of people who are incarcerated? So which way do we want to go first? Kermit, do you want to jump in on the Eighth Amendment's connection to due process and the 14th Amendment and give us that framing? Then Amy will dive into solitary confinement.
Sure. So the Eighth Amendment has some specific prohibitions, and it's got the excessive bail clause, the excessive fines clause, the cruel and unusual punishment clause, which target particular practices that we think the government just shouldn't engage in. And then we've got a raft of other amendments that regulate the criminal process with basically the same goal, which is to protect people who are accused of crimes, understanding that the government has a lot of power and can do a lot of harm to innocent people in this process, and that ordinary people are often not very well equipped to defend themselves, and they don't know what their rights are. So we've got the Fourth Amendment to start, like, going through First Amendment, Second Amendment, Third Amendment. Okay, the Fourth Amendment protects you from unreasonable searches and seizures. So there's a limit on what the government can do if they're trying to gather evidence against you. And the Supreme Court has said if they go too far, if they search your house without probable cause, they can't use the evidence against you. So it's supposed to be a disincentive. Then in the Fifth Amendment, there's a bunch of criminal procedure rights. So you can't be compelled to be a witness against yourself. They can't force you to testify, and the Miranda case says they have to inform you of your rights. You can't be tried twice for the same offense. So if the government can't convict you the first time, they can't try again. You have the right to assistance of counsel. This is the Sixth Amendment, so they recognize that ordinary people aren't necessarily able to defend themselves, right? The government's going to have a lawyer who's familiar with the criminal code and a prosecutor who's done this before. So you get someone on your side who also understands the system. You have the right to a speedy trial. The government can't hold you indefinitely before they actually put you on trial, which, you know, they might want to do to someone they don't like. Like, we're going to charge you with something and just lock you up and never try you. This happens to a bunch of the Guantanamo detainees, and maybe we should think about that. You have a right to call witnesses. So, you know, you get the sort of procedural powers that the government has. They're going to bring in witnesses against you. You can bring in your own witnesses. You can cross-examine the government's witnesses. And you get a jury, perhaps most important. So the people who are deciding whether you've done something wrong and deserve to be punished won't just be members of the government, which judges are. Judges are a different branch. They're not part of the prosecution. They're supposed to be neutral. But you also get a jury of your peers. So the people have a voice in deciding whether you should be punished or not. So there's a whole bunch of constitutional protections that regulate what police can do before they charge you, and what the government can do while you're being detained, and how the trial is going to go. And all of this is supposed to make it more fair.
That was fantastic. Thank you so much for unpacking the whole Constitution on Constitution Day and going through kind of piece by piece. Now, I said this, Amy, before we started, and I'm just going to say it out loud to everybody. This is going to be one of a series where we unpack all those different pieces, because there's so many follow-up questions for each section that you broke down, and say, how does this work in practice? How is this working when you're detained? How does it work afterwards? So Kermit, that was fantastic. Thank you so much. Really helpful foundation. Now, when thinking about, you know, all these pieces in practice and in play, then you're in the prison. And solitary confinement is a tool that prisons have used for years. So Amy, can you tell us a little bit about the battle and the struggles around solitary confinement from the early 1800s till today? The long timeline.
Absolutely. The struggle is ongoing. And it's good that we're talking about this both in the historical context with Eastern State, but also now. So solitary confinement really got going in this country in the early 1800s. And like I said, it had been thought as a humane reform. It was pushed by the Quakers in particular. And the idea was leave a man, and it was a man that they thought of, in a cell by himself with a Bible, and that's all he's able to do. And he won't talk to anybody. He'll just concentrate on his relationship with God. So it was a very religiously motivated issue as well. So this spread in Pennsylvania. It went up to New York as well. Unfortunately, what folks found out soon enough is that when you leave human beings alone with nothing to do and no one to talk to, in total isolation, they start to lose their grip with reality. Bad things happen. People lose their mind. Sometimes when they're released, they are okay, and sometimes they're not, and sometimes they don't make it out. And so by the late 19th century, it was pretty broadly recognized that solitary confinement just didn't work. It wasn't going to reform anybody. It actually hurt people. So we stopped seeing it practiced. Solitary confinement was always partially present. People knew about it, but it was not used on a massive scale because it wasn't seen to be a very useful thing to do to people. And we knew that it hurt people. We've known that for a really, really long time. Unfortunately, in the age of mass incarceration, which I mentioned, this is the 50th year, where we saw unprecedented numbers of people coming into prisons and jails and huge prisons being built across the country. And this was partially as a result of a reaction against the successes of the civil rights movement, the war on drugs started by President Nixon that was targeting the Black community and their political power in a very specific way, as well as, quite frankly, a demographic bump with the baby boom and a surge in crime, which is not unexpected. Young people, and the boomers were young then, young people are the folks who generally commit crime. Age, crime curve, criminology, well established. So we expect when we have a surge of young people that crime will go up. So not unexpected, and certainly in no way accounted for the massive prison buildup that we had in this country and the millions of people we brought into our prisons. They were so overloaded. They were so overtaxed. They stopped doing any kind of rehabilitation. It was a warehouse. And in most places, it continues to be a warehouse. And in order to deal with the problem of warehousing people, the violence that resulted in the warehousing of people and putting them in terrible, desperate conditions, and the feeling that systems were no longer responsible for doing rehabilitation, they started using solitary confinement as a one-size-fits-all punishment. So if you break a prison rule, it could be you have an extra handkerchief or you get into a fight, you end up in solitary confinement. If you are sexually assaulted or a vulnerable person, like a child or somebody who is older, you end up in solitary confinement. It's used as an institutional management process. Unfortunately, then we build entire prisons called supermaxes that put people in solitary confinement. And we're not talking about solitary confinement for a few days, a few hours, a few weeks, a few months. In this country, unlike any other country on the face of this planet, people spend years and even decades in solitary confinement. The result is that the vast majority of people who commit suicide in prisons and jails in this country do it because they're in solitary confinement. It's very clear that people lose their mind. I've been in dozens and dozens of solitary confinement prisons, and I can tell you that the feces, the blood, the screaming, and the number of people who are unable to actually interact in any kind of normal way is overwhelming. There is no question that solitary confinement is torture. I've seen it happen. I have lost clients as a result because they just couldn't take another day. Solitary confinement. In fact, the United Nations now says that any use of solitary confinement over 15 days, it can be torture and it is cruel, inhuman, and degrading treatment. Remember, in this country, 15 days is a very short time in solitary. We're putting people months, years, and even decades. So the US is an outlier. But under the Eighth Amendment, we are trying to evolve that contemporary standard of decency. So we do have some case law in certain federal jurisdictions that says, for example, you can't put some vulnerable populations in solitary confinement. For example, people with serious mental illness. And that would be psychosis, schizophrenia, bipolar disorder. Children, we have gotten some rulings around not putting children in solitary confinement. Pregnant women. We've also gotten some district court rulings around the length of time in solitary confinement. What we don't have is a blanket ruling from the Supreme Court that says placing anyone in solitary confinement for X amount of time is a violation of the Constitution. What we're seeing at the state level, and this is a result of community activism, survivors of solitary confinement, their families, local advocates, lawyers, judges, some corrections folks saying, look, we can't continue business as usual. So we're seeing laws passed at the state level that severely limit and regulate the practice. For example, the state of New York is the first state to adapt the United Nations 15-day limit. And that's called actually the Mandela Rule, named after Nelson Mandela from South Africa, who was placed in solitary confinement by the apartheid regime. A very, very fitting name for that rule. So we are seeing that evolving standard of decency. 23 states now have laws. There are a lot of court settlements. I've worked on a number of them to really limit the amount of time and the number of people and the individuals who can be placed in solitary confinement. It isn't enough. The work is ongoing. It is a struggle in jurisdictions all over the place. It will continue to be until we end mass incarceration, I have no doubt. But the law is in real time evolving because of those contemporary standards. And many of you on this call, I am quite sure you're to help evolve those standards along with us. So I thank you in advance.
Thank you. And it is also National Suicide Awareness Month. So I think that's a very fitting conversation to say, well, we have these conversations and we're looking at this across our nation. We need to look at every part that is impacted by suicide and what is the right way to move suicide prevention forward. Kermit, Amy was talking about, a little bit about federalism here, unpacking how these systems of prisons work and prisons and jails work. Is there an opportunity for a national amendment or for Congress writing a federal law on this? What are your thoughts on putting a 15-day limit on solitary confinement? I think it's 25 states. Around 25 states have some limit on solitary confinement, but that's only 25.
Well, so there are interesting federalism questions. And I should have said before, actually, right, when we were talking about constitutional protections, I was going through the Bill of Rights. The Bill of Rights in 1791 only affects the federal government. So at the time of the founding, the Constitution's creating this new federal government. It's also going to put some limits on what the federal government can do because people are scared this new federal government might become a tyrant. It puts very few limits on the states. So there are a couple of provisions, Bill of Attainders, ex post facto laws, things states can't do, but your free speech rights, your criminal procedure rights, your Eighth Amendment cruel and unusual punishment rights, those aren't good against the states at the founding. States can do what they want. So it's only because of Reconstruction and the 14th Amendment that these provisions start binding the states. And now a question would be, if the national government wants to reform, if the national government is actually sort of the good guy, which is more the role it's played, I think, if you look at the Civil War and the Civil Rights Movement. But if the national government is the good guy and we're concerned about states, maybe not all of them, but we're concerned about states who are straying from the national consensus and doing things that we're concerned about, what can Congress do? Well, one thing you might think about is whether the Eighth Amendment itself is going to come in at some point and say, if a sufficient number of states have abandoned a practice because they think it's barbaric and cruel, now the Eighth Amendment means the rest of them can't do it. To me, that's a very plausible understanding of how the Eighth Amendment works. But another thing you might say is, well, the reason that the Eighth Amendment applies to the states now is because of the Due Process Clause of the 14th Amendment, and Congress has the power to enforce that. So there's a section of the 14th Amendment that says Congress shall have the power to enforce this by appropriate legislation. So if Congress decides, and Congress as a national legislature is probably pretty well positioned to say sort of what the mood of the country is to reflect what American values are. If Congress says this punishment is cruel and unusual, at the least, I would think courts might defer to that. Courts might say, well, if Congress says so, that carries some weight in our decision. Usually courts will say, ultimately, it's up to us to decide if this violates the Constitution. But they might defer to Congress. So I think plausibly, in terms of the Constitution, politically, it's a totally different question, what would happen. But in terms of the Constitution, I think you could absolutely get prison reform legislation from Congress in the name of enforcing the 14th Amendment.
Thank you. What a great way to break it down. I really do also appreciate you said plausibly this is the power in and around the Constitution. Politically, it might be a different conversation. And I think that's important too, because when we look at making changes or shoring up what we have, it really works both ways. We have to think both politically and constitutionally, how do we make these changes, or what do we already have that we need to just enforce? I promised I would go to audience questions. Warren asked a really, foundational one, and I think it's a fantastic question to help us understand where the power comes from in the first place. So Warren's question is, how can taking a citizen's life by the state be permitted? So this goes into the conversation around, one of the court cases that Amy, that I really wanted you to talk about as well, which is Barber versus Ivy. But can we talk about execution? And so Kermit, maybe you can start this off with giving us our foundation of how can the state be permitted to take somebody's life? And then Amy, we turn it over to you to bring in kind of a very recent case in the Supreme Court just last year.
Right. So how can the state be permitted to take a person's life? The feeling behind the question, I think, is that that's inappropriate for the state to do. It's not the proper role of the government. It's barbaric or cruel or something like that. But historically, it's very well established that this is something the government has done for a long time. And it used to be the case that lots of crimes that we would no longer permit the death penalty to be imposed for, lots of crimes were punished by death. So you start with that, and then there's also an explicit reference to this, it seems like, in the Constitution. The Fifth Amendment says that people shall not be deprived of life, liberty, or property without due process of law, which suggests, right, if you follow due process, you can deprive them of life. Now, some people think that means the death penalty can never be constitutionally challenged. I don't think so. I think it's perfectly plausible for the Constitution to recognize limitations on a practice that's okay in 1787, right? Yes, people can be executed, but not without due process of law. And then as times change, if we have this understanding of the Eighth Amendment whereby the set of prohibited punishments can change, if people decide that something is cruel and they abandon it so it becomes unusual, I think things that were okay in 1787 could stop being okay in 2023. But the Supreme Court hasn't said that yet. There have been cases about the death penalty for a while. The court thought that it was being imposed in an unacceptable way. But the idea that the state simply can never execute people no matter what they do, that's a stretch. That's like several hurdles ahead, I think. It gets a lot easier if you look at international practice. So one of the things that I mentioned before was in 1791, when we get the Eighth Amendment, the founders are saying, we don't want to be like France and Spain and Germany because they have these barbaric and cruel punishments. Nowadays, it's more people who are saying, who are trying to limit the government's authority to punish, who are saying we should look to Europe, we should look to the community of civilized nations, because most of them have gotten rid of the death penalty and we're an outlier now. It's an interesting question when you're trying to decide whether something is unusual. Do you look at US practice, or can you broaden the lens to look at what other countries do also?
Thank you. That's a really powerful way to kind of examine it, look at our history, and apply those same applications to today. So thank you. Amy, do you want to kind of unpack that court case from the last term and talk about what was going on? When we posted this program, we had a lot of people reach out to us and bring up that case and say, what's going on in Georgia and Alabama? What are going on in these prisons? And tell us what the Supreme Court saw as a part of the emergency docket, I believe.
Yes, yeah, and obviously the death penalty dialogue and controversy in this country is very much ongoing. When we are seeing, increasingly state by state, it is being outlawed at the state level and not at the federal level. And we are also seeing a switch in overall American opinions about the death penalty. But nonetheless, it is alive and well in too many of our jurisdictions, from my point of view, having represented so many people on death row. We do have limitations, as the professor alluded to. We no longer execute people who committed their crimes when they're children. The Supreme Court found that unconstitutional in the early 2000s. And we do not execute people who have cognitive disabilities anymore. They are also a protected class. And that was in the early 2000s. And that did impact a fair number of people, because when we looked at the population on death row, so many were children and so many have cognitive disabilities. I know that from my own clients who now are no longer on death row. Nonetheless, controversy continues and is part of the process of really the evolution of our contemporary ideals. I would say that what we've seen increasingly are problems that occur with execution. The Eighth Amendment is concerned with the wanton infliction of pain and unnecessary infliction of pain. It is also concerned with proportionality of punishment. And so the idea always was, well, the state has the power to execute, but it will do so humanely. Unfortunately, what we've seen is not only do jurisdictions that still practice the death penalty have problems with their executions, and one of the reasons is they cannot get the drugs to actually execute somebody because companies simply don't want to sell drugs to execute people anymore. It's bad for business. Many of them are European companies, so they want nothing to do with American executions. And there's also the issue that doctors, under their oath to support people's health and not hurt people, cannot participate in executions. Doctors in this country don't participate in executions. And so what happens is that officers who are not medical personnel are the ones who are often engaging in the executions, and things go wrong. And in places like Alabama, that was the subject of this recent Supreme Court decision, they go wrong a lot. And so we have evidence that people are not being executed humanely. In fact, they are suffering enormously during execution. Alabama in particular has had a number of botched executions. And so as a result, a gentleman who's on death row petitioned the court saying, look, this is inhumane. Alabama has botched executions. They're going to botch mine, and I am going to be tortured by this. That's a violation of our Eighth Amendment. But the court decided not to hear that decision, and in very cursory decision in which the majority said they would not intervene, essentially, written by Justice Thomas, I believe, and with 3 dissenting opinions. I bet all of you can probably guess who those 3 justices were, because what we have right now in this country is a deeply divided court, and a court that is seen as immensely political in a way that the Supreme Court never has in its history. That's a problem for our democracy, frankly, and probably the discussion for another day. But trust in the court is really at an all-time low because of the clear partisanship that we're seeing from some of the justices, and frankly, some unfortunate, perhaps moral issues that are arising with conflicts of interest in some of the justices. But right now in this country, the status quo is that executions are they are lessening. There is no question about that. Even in places like Oklahoma, they are still occurring, and there are serious questions about how exactly humane these executions could possibly ever be.
Thank you, Amy. That was a really powerful way to kind of look at these cases and bring in the understanding. You said it so unbelievably well. When we're looking at the Eighth Amendment, we're looking at, are things fairly applied? Is the punishment fairly applied in a humane way? And so often with a lot of the Constitution, that is the system that we'll try to establish. We're trying to put these out. Before we wrap up today, and I know we're a couple of minutes over, but I wanted to give kind of the last word on that conversation of looking at the courts and these cases that are coming to the courts around the death penalty. Back to Kermit, and any insight in future cases moving forward and where the court sits right now on these cases. Not a little crystal ball for you, but a little bit.
Well, so I would probably just echo a lot of what Amy said, and maybe amplify it a little bit, although I think she's right that this is a topic for another day. But we do have a Supreme Court that looks pretty extreme, and it looks political to people. And why is that? Well, I think part of the question is what the proper role of the Supreme Court should be and what kinds of questions come to the Supreme Court. And under the Constitution that we have, with a lot of sort of vaguely written, value-laden provisions, of which maybe the Eighth Amendment is one, because it talks about cruel, the Supreme Court has to make a lot of sort of judgment calls. And those decisions are in some way inescapably political. I think they don't look very political as long as the court is reflecting mainstream American values. So one way that I put this sometimes is to say, like, politics are kind of invisible if they're your politics. And the reason that this court looks more political isn't necessarily that it's making decisions that are different in quality from the kinds of decisions the court made in the past. It's more that its decisions are outside the mainstream of American values. And the reason for that has to do with the appointments process and how we got this current 6-3 conservative majority on the Supreme Court, despite the fact that presidential elections over the past 30 years have not tilted that extremely in favor of the Republican Party. But that's really sort of a question about term limits and the appointments process, which is also something that I'm working on, but not so much our topic today. But I would just put that out there as another way in which the Constitution could be improved. So we can always get better, we can be a better people, we can refine our moral sentiments, we can improve as individuals, we can improve politically, we can try to make changes through the political process, and we can also improve the Constitution.
Thank you so much, Kermit. Thank you so much, Amy. That was an unbelievably powerful way to wrap up in a very positive way, an extremely hard topic. So our goal here at Eastern State is to really engage our audience in the awareness, education, and understanding of the criminal justice reform movement. And that can be extremely hard for people to grapple with and understand. Our questions in the Q&A and the chat today were so powerful, but it really is a responsibility of what we have to be a part of this society. We have to look at the beautiful celebratory moments and the really hard ones as well, and not forget that people are involved in this process. It's not just the cases, not just the court. It are people who are affected in so many ways by the criminal justice system. And we thank you both so much today for bringing what, was established in 1787 and 1791 to a modern dialogue today, and that many people listening today and in our communities have a direct impact in their lives on. So thank you so much. Now we can't wait to do more of these programs and unpack even further. Thank you for kicking off the season. It was wonderful to have you both.
Thank you for having me. It's been really fun.
Yeah, thank you.
Thank you, Amy. Thank you, Kermit. Thank you, students. Everybody have a fantastic day and happy Constitution Day.